For more on this, we now speak to Jimmy Moyaha, who is an independent analyst and the host of SAFM Market Update, and he joins us via our telephone line. Jimmy, thank you so much for joining us this evening here on SABC News. I mean, let's start off here. We have seen the Competition Appeals Court dismissing this matter, and of course, they're exonerating at least 28 banks. Essentially, what does this mean for rand manipulation, and what does this mean generally for South Africans?
Bali, and good evening to the viewers. Effectively, this means that the case that was initially started almost 10 years ago in 2015 is coming to an end, and there might not be avenues to pursue beyond the current avenues. So in a nutshell, the judgment speaks to two main points. That, first of all, the Competition Commission did not have the authority or the jurisdiction to conduct the investigation along these lines. But secondly, and this is probably equally as concerning, is that there was insufficient evidence to prosecute or to pursue a cartel case against the banks. So what this means is now it's back to the drawing board effectively for the Commission. They have to, first of all, if they are to continue the pursuit of evidence and the gathering of evidence, that they would then have to gather evidence that would be sufficient enough or damning enough for a cartel case to be something that can be pursued. And then secondly, we would then need to establish which authority would be the relevant authority that would have the jurisdiction to pursue the case to investigate the matter. So, I mean, we'd be looking at anywhere from the South African Reserve Bank to the FSTA to potentially even international or regulatory bodies, as the appeal court ruled that it's likely that the jurisdiction would sit outside of South Africa's investigative jurisdiction. So what you might find is it would sit with an organization like the SEC, the Securities and Exchange Commission in the US, and they might ask for assistance from the FSCA. But again, as the insert rightly pointed out, that there is a lot of complexities around currency cases, and the onus and the burden of proof is what's going to set this case apart from everything else, and needing to prove that there was indeed intent to manipulate the currency or to influence the currency. That's going to be one of the hardest things to prove in a free market situation where orders come into the market on a daily basis, on an hourly basis, on a minute basis, in fact, and it's very difficult to tell which of these orders would qualify as part of the manipulation and which wouldn't.
And Jimmy, I'm sure a number of South Africans are asking themselves, I mean, this is a case that caused a lot of uproar in the country, and many were questioning whether, you know, there was this rand manipulation or not. What does it mean now for rand manipulation? Was there a rand manipulation here?
So that's the interesting conversation that's being had at the moment. There's a lot of schools of thought, whether from a legal perspective or from just a logic perspective, to say that, at least legally, everybody in this case, whether banks involved or not, are deemed to be innocent until proven guilty by South African law. That is how our law is structured. But if you look at the fact that there were banks that admitted to guilt, and there were 2 banks, in fact, out of the 28 that actually paid a settlement amount in the form of Standard Chartered as well as Citibank back in 2017. It does lead one to believe that where there is smoke, there may be a fire. Where there's a smoking gun, it may be worth looking into it. I mean, if you look at the names of the banks that pled guilty or that admitted guilt, it's not small banks. I mean, we're talking the likes of HSBC, BNP Paribas in France, and the JP Morgan and Chase Bank in the US, and the formerly Swiss bank known as Credit Suisse. So you're not dealing with small time banks that would be considered your middle tier banks or your regional banks. These are global powerhouses that have a that they themselves admitted to being implicated and requested from the U.S. In the case that they were dealing with in the United States, they pled for leniency and asked to settle with the Commission as a result. So that begs the question to say, if the banks were willing to do that, and if you think about the settlement amount of 70 million rand that was paid by Citibank back in 2017 and the 40 million that was paid by Standard Chartered, I think just recently, that also raises the question of, if these banks were willing to pay that much to settle, is there more to the story? Is there more to investigate? And if that is the case, the bigger question, back to what we had initially said, is how do you then investigate? How do you then prove it? If, existence of this group, this WhatsApp conversation group, this chat group where all of these discussions took place, then it becomes even harder to prove. And even if there is an existence of that chat group, what was discussed in that chat group, is it enough to then have a case or to make a case against the banks? At the moment, that is what the Commission needs to figure out. That is what any other investigating authority needs to look at, is to say what evidence is available, and is that evidence sufficient for it to be made.
All right, Jimmy, thank you so much for your time. That is Jimmy Moyaha, an independent analyst and the host of SAFM Market Update.